Hello, everyone. Thank you for joining me again today. My name is Michael Wier. I'm a technical marketing engineer for cybersecurity here at Ingram Micro. Here today to talk to you about U.S. state-level privacy laws, an overview for businesses and MSPs. Now, privacy, obviously, there's a lot of different privacy laws, but if you can't guess by my title, cybersecurity, we're talking about the cybersecurity privacy laws that there are at the state level here in the United States, and we're majorly talking about new ones, not ones that have been on the books for a long time, or ones for which there is a recent revision. Agenda for today. First thing I'm going to do is talk about the major ones. We're going to talk about the implications or requirements they might have for businesses, and we're going to talk about how MSPs can help. Now, I'm going to advise you right off the bat, this is a very dry presentation. If you forgot your antiperspirant today, just watch it. It'll dry it right up. So most of these can be broken down into 4 different levels. So there is the personal information aspect of it, PI. This is what is collected, by who, and what can it be used for, and how, and that kind of thing. There's a tracking aspect to it, which is, your web browser, your device location, these personal things that say not just who you are, but where you have been and what you've done there. There's an aspect of children's protection in them, which is increased scrutiny for the information that's coming from minors. Specifically things targeted at minors in some cases, and what the definition of a minor is. The grayed out one there is employee monitoring. Think about that as saying who in your company can have data access. That's in a lot of those too. We're not going to talk about that as much today. That's more dependent on your existing internal policies, that kind of thing. All right, so let's get to talking about these major ones. We're going to talk about 4 major states, and we're going to talk about a couple other hang-arounds after that. First one we're going to talk about is the California, the ccpa and CPRA. If you have anything to do with cybersecurity and data protection, you've probably heard about these. They're the big news, sort of equivalent to the European GDPR, where they're making big waves and big changes. There's a whole bunch of acronyms on here, just to give you quick definitions. These acronyms and their definitions are going to hold true for most of the standards we're going to look at. So PI is personal information. SPI is sensitive personal information. This is your precise geolocation, race, ethnicity, religion. Some of these standards include genetic data in it, private communications, sexual orientation, health information. That's your SPI. CLI is not command line interface like most of us tech people think. It stands for consumer login information, username, password, factors, that sort of thing. That's just to hit the acronyms that are on here right quick. So I'll let you read these while I speak, and pause the video if you want to read them in greater depth. I'm not going to read them out loud to you, but I will say the theme of the CCPA and the CPRA is about consumers controlling their data, what is collected and when and how it is used. So it's very much focused on consumer data control. And for their purposes, I talked about child protection before. A minor is anyone under 16. If you're collecting data or tracking data in any way that violates this law, for someone that is under 16, you get triple penalties. Given that the penalty is already pretty stiff, that's not necessarily a good thing. Next state we're going to talk about is Colorado. So Colorado, we talked about in the California one there, it's majorly focused on consumers and their data and their access to it. The Colorado Privacy Act is based more around organizations than it is necessarily consumers. It says that, generally speaking, your PI must be protected, and someone in an organization must make sure that it's being protected, and people should be able to figure out if it's being protected. And for the purposes of the Colorado law, a minor is anyone under 13. So there's going to be enhanced enforcement for any information coming from people under 13. Utah, which I found to be kind of a weird state on this list, but it is what it is. Their themes are similar to the CCPA, but they add more in the ways of specific safeguards. Safeguards, and I could imagine this in the California slide as well. It's the right to opt out of having your data collected, the right of finding out what data they have, and the right of erasure if you don't want them to have that data. Like our previous one, Colorado, a minor is defined as someone who is age 13 years old or younger. And then the last one, major one we're going to talk about that's been passed, is the Virginia CDPA, Consumer Data Protection Act. This is also similar to the CCPA, and it's about consumer control over data. One of the things that's unique about the Virginia version here, though, is that there's exceptions in it, specifically for state, local, and federal agencies, as well as small businesses. As far as what those are, that's something for a much more specific conversation, but just know that there are things to do with, hey, this is within your ability, or hey, the state, local government, federal government have a controlling interest in knowing these things without you knowing that they know these things. One other thing about this is it's actually explicitly funded enforcement, so theoretically speaking, the enforcement might end up being better. The others sort of have it under their either as agency as a whole, the same people they're studying and that kind of thing, or just part of their normal law enforcement budget. And once again, this is just like the other 3 states where a minor is somebody 13 years of age or younger. And when I said there was a little bit of a hanger-on, so as of this writing right now, there's a potential joiner of the Connecticut DPA, Data Protection Act. This is something that's augmenting an existing law that they have, but it's explicitly adding cyber data types. And the reason I'm calling this one out explicitly is because they're now including biometric data and anonymized data. So biometric, of course, being Face ID, fingerprint, that kind of thing. And then anonymized data, there's things you can do with data stores of various programs to take data and either hash part of it out for certain users or encrypt parts of it and other people can't get to it. This is for even data that's been anonymized, because theoretically speaking, if somebody followed the data closely enough, they could compare it back to a person and get an answer there. In terms of states with laws in committee, there's a whole bunch there: Louisiana, Massachusetts, Michigan, New York, New Jersey, North Carolina, Ohio, Pennsylvania, Rhode Island. Maybe someday there'll be a future video where we set out and we go through each of those one by one. That's gonna depend a lot on how many views this gets and how much people actually want that. If you're from one of these states, feel free to contact me. Contact information for me is at the end. I can study these things because I have the time to, and as a business or an MSP, you might not necessarily have that. Anyway, implications and requirements of these things, what's going to happen to businesses because of this. So there's a few implications here. The biggest one, no matter how you slice it, is that what laws apply to you are determined by the location of the user in most cases, not the resource. So your website may be based, in Florida, somewhere it doesn't have a regulation yet. But if people from California regularly use it, then you've got to accommodate the laws that California has. Most of these, though, and sort of good news, require some kind of action by the user. So the user has to say, hey, erase my data, hey, what do you have, that kind of thing. There's not going to be somebody coming in necessarily and auditing right off the bat. Not going to say I'm going to rule that out all the time for every policy all the way down the line. But most of them, you've got to have the policy in place. But the actual actions of divvying out the data, the user is the one that initiates that. Though, to help out that user, there's text in almost all these standards that says there have to be easily understandable policies. So, I can't go to a page and it says like reject all cookies, and when I click reject all, it's actually me rejecting my ability to reject, so they're all being saved or something like that. There can't be legalese. It has to be something that the average person could look at and understand. And last, the definition of minor aimed content or determining age is really blurry on the internet. This is something that's dogged the internet since the very inception as a publicly accessible resource, is how do we tell who is a minor and what they're doing? Now, the risks as a website, you're tripling penalties in some cases. These things are so much worse if you're getting a minor's information that in a lot of cases, for people who don't really have the ability to make a very nuanced access policy, it might be safer just to play everything as though everyone's a minor. Or, what is minor age content? That's something that's kind of tough to define. What does a minor go to these days? Sure, Facebook and all those things, they say, you can't have a profile if you're under 14. Mostly they say a minor is 13 or under, but I'm sure we all know people, have relatives, cousins, things along those lines that are under that age that have Facebook profiles. So those are the implications for business in terms of things that will be required from the businesses thanks to these things. I divided it up like this. This is proactive requirements and reactive requirements. And it's worth saying at this point, none of this should be construed as legal advice. I'm not a lawyer, et cetera, et cetera. Proactive requirements. You're going to have some policies if you're a business or you're an MSP serving a business. You're going to have definite policies to make sure that all data is being handled uniformly. You're probably going to get a lot of things called DSAR, Data Subject Access Requests. And those go a lot smoother if you have some kind of policy in place so you can find things right off the bat instead of going on a multi-day hunt that's going to cost you hours and dollars because one person requested one thing. You're also going to have to set up data protection ahead of time. Not just from these, but from tons of other standards. There is monetary fiscal penalties for being breached right now. And some standards you can actually lose your right to do business in that vertical or with that thing. Like, PCI breach. You could potentially lose the ability to transact credit cards, which is going to really mess most people up. Another proactive requirement is consumer notifications. What I said about things being in plain language. I use the cookie rejection thing a lot because it's one of the things we see most frequently in our day-to-day internet usage. There have to be clear consumer notifications that you have to design and put out there in the appropriate language. There are also the reactive requirements. I talked about DSAR coming in data subject access requests. When somebody makes those, you need to find that data. And as I said before, you don't want to spend money and hours finding data for one person. You want to have a way to do that quickly. So when the data is demanded, you can say, okay, here it is. You also need to do some explaining on demand for things like the ccpa. People have the right to ask, what are you doing with the data, or how do you have to, to a certain extent, why are you gathering this data from me? If you don't have good policies in place, that becomes reactive. Even if you do have good policies in place, that's something you need to be able to hand out. And for some of these, when there's been a violation, they're typically not audited, but if there's been a violation, you have to prove that, hey, everything was in line. This violation was either somebody's misuse, an employee on our side doing something badly, somebody not clicking something on a website. It wasn't something that was structurally wrong with our organization. So how can an MSP help in this situation? This is just a few things. Obviously, MSPs, there's such a huge shortage between the number of cybersecurity professionals that are needed out there and the numbers that actually exist or even remotely qualified to do some of these jobs. But an MSP can supplement a bench. And this is what they can really do. So first would be stay on top of the laws. Most businesses don't have time to have somebody sit down and research every law in their state regarding cybersecurity, or even one of them. Right? An MSP can help with that. They can stay on top of laws for you. Next would be preparing your data policies. As I said, having data policies beforehand is key. If you're an MSSP, you can help people craft these data policies proactively before there are problems. So when it comes to the time that there is a situation, all those policies are already in place. It's just a matter of implementing. And then, of course, the big one, implementing the actual data controls on new and on existing data. So first is going to be helping people handle their data, which is find, classify, track, and automate getting that data out from wherever it is. Find is actually way harder than you think it is. I recommend using tools for that. There's a couple of different ones out there, PKWare, for example. And then there's controlling access to data. This is your zero trust access. It's a buzzword. It's everywhere. It's also your identity and access management part of which is your multi-factor authentication. You want to verify who is accessing this data, when and why. And in the IAM, have that why and those permissions already set up, rather than have to go back and say, all right, Pat, why did you access this information here, there, what have you. As I said, there's a lot of content in these things, so if you don't have the time, the bandwidth, or the know-how to go through all of this, let us help you. So that's my email address at first, michael.wier@ingrammicro.com. I'm here to help you out and go through these things. I have the time in my day to become an expert because I know you might not necessarily have that. We also have a website, securitylinecard.com, that lists off all the products and vendors that Ingram Micro has in the cybersecurity space, sortable by ability and what they fulfill. And of course, if you just need some thought pieces, imaginex.ingrammicro.com/security. Thank you for joining me today, and don't forget to realize the promise of technology.